So my name is Worsham, and I really do appreciate you coming tonight and giving me your time to let me talk to you a little bit about estate planning. It's something that I got into. I'm going to tell you about why and how and all that tonight as we talk a little bit, but I need to tell you a little bit about myself. So some of the things I'm going to say as we walk through the program tonight make sense. So I started practicing law in 1996, so I've been an attorney for almost 28 years at this point. Started my career as a prosecutor, then went on to do criminal defense work, and then decided to switch a few years to estate planning. I'll tell you why I decided to do that in a little bit. I have a family, I have a wife, I have 3 children. I'm an elder for my church here in Rogersville at Fellowship Bible Church. I serve as a municipal judge for the city of Rogersville. I serve as a municipal judge for the city of Stratford. And I have a 4th degree black belt in Taekwondo. So that's all relevant, I promise. It's going to make a difference here. But when I started my career as an assistant prosecutor in Greene County, what I did every day was I went to court. And so I was in court handling all the criminal cases. And what would always happen is you'd have the same guys coming in all the time. The same criminal defense guys would come in all the time handling their criminal defense cases. But every once in a while, a different kind of lawyer would show up. We always called them the big suit lawyers because they had big fancy suits because they worked in big fancy courtrooms. And they had really no business in my court doing criminal cases, but they were always there because one of their business clients' kids had gotten a traffic ticket. And they wanted us to fix their traffic ticket so it wouldn't go on their record and their insurance rates wouldn't go up. And we would do that. That was part of what we did. But when I left the prosecutor's office to start my own practice, I was thinking about, how to build a practice. I was brand new. Nobody knew who I was. And I got to thinking about that. And I said, nobody really knows. This is the late 1900s. Way back then, nobody knew much about fixing traffic tickets back then. But I decided maybe that was something I could do differently. And there was a new thing out then too called the internet. And so what I did was I built a website called MissouriTrafficTickets.com. Now before I did that, I called around to see what other lawyers charged when if somebody called and asked them to fix a traffic ticket, and they charged $500, which was the attorney fee, if you wanted them to go to court and handle your traffic ticket. But I decided that if I could use the internet and do things a little bit differently, I could charge less. And so I only charged $75 was my attorney fee to go to court and fix somebody's traffic ticket. And the other lawyers thought I was crazy. They said, you can't go spend 2 hours in court for $75 and fix one traffic ticket. And they're right, you can't do that. You can't make a living doing that. But I didn't do that. I would go on 20 because I had the internet. So I used MissouriTrafficTickets.com, and we got people to where we could do a lot of traffic tickets. And that worked out really well. In fact, I built that practice to the point where I was fixing 200 to 300 traffic tickets every month. In addition to that, I was handling my regular criminal defense practice, which meant I was driving all over Southwest Missouri in a suit, in a car, in a courtroom, handling everything from traffic tickets to first-degree murder cases while I was doing criminal defense work. And I had a friend, and he said, you can't do that for your entire career. You're burning yourself out. You got a wife, you got some young kids, and you need to do something different. And he was right, and he referred me to a program called Strategic Coach. Now, Strategic Coach is an entrepreneurial coaching program, and so once a quarter I would fly to Chicago and sit in a room just like this with business people from all around the country, and we had a coach, and they would coach us on how to run our businesses better to where we wouldn't spend all of our time and wear ourselves out and burn ourselves out. And it was a really good program, and I got really great tips, but I got one thing that absolutely made a huge difference in my life. I'm sitting there in the afternoon and a table kind of like that, and I'm getting sleepy because it's the afternoon. Afternoons are nap time for me. I can barely keep my eyes open when it's nap time. And she showed us a video. And that video really changed my perspective on how I wanted to conduct my business. And so I'd like to take the opportunity, about 3 minutes, I want to show it to you before we get started.
How do I know? A lot of people, when they think of the phrase, how do I know, they always want to put the what behind it. How do I know what I'm supposed to do? The question that you really should ask is, how do I know why I'm here? Because when you know your why, your what becomes more clear and more impactful. If you know, like for instance, people know that I do comedy, but that's what I do. My why is to inspire people to walk in purpose. So I can do comedy, I can write books, I can be in a movie, because all of it is motivated by my why. In fact, I have a new web series out called Michael Jr. Break Time. We probably just did the 6th episode. It's on YouTube. So every single Wednesday at 3 o'clock, we drop a new episode on YouTube of Michael Jr. Break Time. What it is it's me. I travel around the country, and I do stand-up comedy, in case you didn't know. And in the middle of my comedy set sometime, I'll stop and just talk to my audience. And we've been filming this, and it's pretty cool. So we're in Winston-Salem. I'm going to show you a clip from Winston-Salem. And I'm just talking to this guy in the audience, and he tells me that he's a musical instructor at a school. So I was like, all right, you're a musical instructor. You know, can you sing? Let me hear you sing a song. So this is what happened at the last episode of Michael Jr.'s Break Time. Check it. So you're a musical director. Cool.
Yes, sir.
All right, so let me get a couple bars of like Amazing Grace. Can you do the first part of that? Go ahead.
Amazing grace, how sweet the sound that saved a wretch like me.
Wow. That bro could sing. You know what I'm saying? All right. Now, what you give me the version is if your uncle just got out of jail, you got shot in the back when you was a kid. I'm just saying, let me see the hood version real quick, if you know which version I'm talking about. Just see if that exists. Let me see what you got.
Amazing grace, how sweet the sound that saved a wretch like me. I once was lost, but now, right now I'm found, was blind, but now I see.
Okay, here's what I want you to catch. The first time I asked him to sing, he knew what he was doing. The second time, he knew why he was doing it. When you know your why, your what becomes more impactful because you're walking towards or in your purpose.
Made an impact on me. It's like, why are you doing what you're doing? And so I thought about that a little bit, and I wrote a personal mission statement as a result of watching that video. And so my personal mission statement is to glorify my God, protect my family, support my community, and make communists uncomfortable. And so I had to think about, what do I want to do that's going to be consistent with that mission statement? And I knew it meant I couldn't be spending all my time in a suit in a car in a courtroom anymore. So I started thinking about how I wanted to change my practice and what I wanted to do differently. And as I'm thinking about what I thought I should do, I wanted to do something kind of like I did with MissouriTrafficTickets.com, where we took something that maybe wasn't accessible, maybe wasn't working for a lot of people, and bring it to more people and make it more accessible and simpler. And I remembered Fern and Pete. Fern and Pete lived in Springfield. Pete was a mail carrier, and Fern primarily kept the home. Now, Fern actually, she did some jobs outside the home. One of the places she worked was the Shepherd of Hills gift shop down in Branson. And I remember telling me one time, she said, people come from all over the country to come to Branson, and they got their own ideas about what it's like around here. She said, they're always coming up to me and saying, where can we find the hillbillies? And she said, I finally just told them, I said, I'm the hillbilly, you're looking at them. And I really like that she said that, because I think I'm a hillbilly too. I'm kind of proud of it. In fact, I wrote a book a while back, and our publisher had us all down to St. Augustine, Florida, a bunch of people that he published our books. And we're introducing ourselves, and it came to my turn. They said, I just looked at them, I said, have you ever seen the Beverly Hillbillies? They said, yeah. I said, well, we were neighbors before they moved. And that's kind of how I like to introduce myself to people anyway. But Fern and Pete, they only had one son. His name was Danny. He's an only child. Danny married Diane. Diane, coincidentally, was also an only child. Now, Danny and Diane, they had two children, Brent and Shelby. Now, at some point, Danny and Diane got divorced. And after Danny got divorced, he got remarried. And his second wife had her own children. They, of course, became Danny's adult stepchildren. Okay? Now, I never met Pete, but I met Fern, and when I met her, she lived by herself in the home that she and Pete had built or bought and paid for themselves, and she lived there alone. And she was good with money, but she wasn't a very good cook, so she'd take us to eat out, and that was okay. But she was really good with money. But at some point, Fern had a stroke, and when Fern had a stroke, she decided she could not live alone there at that house anymore. So she sold it, and she moved to the Montclair, right there in Springfield, right, the Montclair. And she lived there for a few years before Fern passed away. Now, when Fern passed away, it turned out she did not have any estate plan, but it was okay because Danny, being her only son, he was able to go ahead and inherit everything from her, and that's okay. We like that. We're glad that it happened that way. But then something a little bit unusual happened. Danny, he was a Vietnam veteran. He worked for Missouri Farm Bureau. He spent his career in life insurance as a life insurance executive. But he got lung cancer. He was a lifelong smoker, and he died fairly young also. And we found out that when Danny died, he also did not have an estate plan. So think about what happens when Danny, who's inherited everything from his parents, dies young in this situation without an estate plan. What do you think happened to everything he inherited from his parents? His second wife gets it. What do you think she's going to do with it? Give it to her kids. What's going to happen to Brent and Shelby? Yeah, so I tell that story. I know that story. Shelby's my wife. And so when I was driving around all over the country in the suit in a car in a courtroom, that's something that happened. So it kind of stuck with me. Maybe there's something wrong with estate planning because we've got people that know better. Fern, she's good with money. She pays attention to that kind of stuff, doesn't have an estate plan. Danny spends his entire career in life insurance and doesn't have an estate plan. So it got me thinking, if we're going to solve some problems, first of all, we have to figure out, why do people not plan? Why do people put off estate planning? And I think I have a good idea to illustrate my point here. And to do that, I would like to teach someone how to break a board with their bare hands tonight. So I just need a volunteer. I have a 4th degree black belt. I'm a nationally certified instructor. I can teach you. I've taught hundreds of people how to break boards. Just somebody volunteer for me, please.
I'll do it.
All right, Tom. You've never done this before. You've not done this before, have you?
Nope.
Okay. Don't need a ringer. Come on up. So you can just stand right there for me and kind of face this way. Get your phone out, Sue. You're going to want
Yeah.
All right, just stand relaxed, put your hands up just like this, and put your thumbs right next to your hand. Kind of just, can you squeeze your hands tight? You felt how your hand got pretty hard?
Right.
You right-handed?
Right.
Okay, put your right hand out for me, pull your left hand back. Okay, this is what we call our ending point. That's kind of what you're going to look like when you're done breaking the board, right? Now when we start, we just do it the other way. So show me what starting looks like. So we're going to pull our right hand back and push our left hand out. That's our starting position. Okay. So the trick to this is when you hit with that hand, you pull this one back. You think about pulling that back as fast as you can. Okay? Because rotate your shoulders when you do that. Yes, show me what that looks like and leave that hand out there. Good, stay right there. We'll practice on this. Now when I hold the board, I'm going to hold the corners. I'm going to hold it just like that. Because you're going to hit with this part of your hand, not your fingers, right? You're going to break right through it. So we'll practice. So show me your starting position again. Look right here and hit it. Just like that. That was a good hit. One more time, leave it out there. Give me, yeah. You didn't go, yeah.
Please go faster.
Yeah. One more time and leave it out there. Yeah. Stay there. Leave it out there. Don't move. Okay, you're going to rip right through this, Tom. I promise. Come out there. Don't move. Okay, right there. Good. Okay, down, because if you break the middle out, it needs to hit me in the chest, not the moneymaker. All right. So show me your starting position and break it. Yeah. Just like that. There you go. Good break. Okay. Why does no one want to volunteer to learn how to break a board?
Chicken. Embarrassment.
Yeah, we were afraid, right? Embarrassment. Who said that? That's good. That's good. Because why would we be embarrassed?
If we didn't break it.
Yeah, because sometimes we're afraid of what? We're afraid of failure. Yeah. Anybody afraid that if they didn't break the board, it might hurt? Yeah. Tom wasn't afraid. But sometimes we're afraid we're going to get hurt. Sometimes we're afraid we're not going to have a good time. But all I have to do is spend about 2 minutes and teach Tom how to do it. We get rid of that fear. When we have a little education, when we know how to do something, we're not afraid of it anymore. And so if we're afraid of estate planning, what we need to do is have a little bit of education to overcome our fear, and that's what we're doing tonight. We're going to take not 3 years of law school or 28 years of legal practice. We're going to take about 60 to 90 minutes. And we're going to learn enough about estate planning to know that when we do it, we're going to be successful, we're not going to get hurt, and we're going to have a good time. Sound like a plan? Awesome. Did you know that they say most estate plans fail? Kind of scary, isn't it? So Forbes magazine puts this out, and I think this is why people are afraid, is we read things like this that say most estate plans fail. And this even says estate planners know that many plans don't produce the results that their clients are going to intend. And heirs often aren't prepared and don't have the skills to inherit the wealth. So that's a little scary. That's a good reason maybe we would have some fear about doing our estate planning. I want to also tell you about Bill and Bonnie. Bill and Bonnie were Diane's parents. So this is my wife's other set of grandparents, right? So Bill and Bonnie, they've passed away now, and Bonnie outlived Bill by about 1.5 years. And when she passed away, Diane asked me if I could help figure out how to settle their estate. And I asked her, I said, do they have an estate plan? And she said, no. I said, okay. Well, they had a bank account. We figured out how to deal with that. But they had a house here in Rogersville. We had to figure out how to deal with that. And so the next time I was in a suit and a car in a courtroom over in Marshfield, handling a case for Webster County, I went to the Recorder of Deeds office right over there in the courthouse. And I did a name search. You can log on the computer. You can do a search by name to find deeds, because I wanted to find the deed to the house that they lived in. And I found that deed, and we were able to take care of that. But when I did the name search, I found another deed. And when I found that deed, it caught my eye because it said it was owned by Bill and Bonnell Klaus, trustees of the Bill and Bonnell Klaus Revocable Living Trust. I thought, well, that's odd. Diane told me they didn't have a estate plan, but here I have that they used to own a house that was owned by a trust, which is a common way of doing estate planning. So I went back to Diane. I said, are you sure they didn't have an estate plan? Because I found this deed. She said, I knew nothing about it. And she'd been through all the papers and couldn't find it. And frankly, even if we could have found it, it wouldn't do any good because their house they lived in when they passed away was not owned by the trust. Their bank accounts were not owned by the trust. The cards were not positioned to work with the trust. So it would not have done any good even if we could have found it. But what that told me when I found that deed is that Bill and Bonnell went to the time, trouble, and expense and hired a lawyer and drafted an estate plan, and it did them no good whatsoever. And I thought, aha, second time in my own family estate planning has failed. First time we just didn't do it. Second time we did it, we didn't know what to do with it, and we abandoned it. And I'm thinking, maybe I've got something I can work with here. So why do we want to plan? Well, we may want to plan to avoid family conflict. You know, people will fight about money, but they'll fight about things a lot of times worse than they'll fight about money. When I was an assistant prosecutor in Greene County, I got handed a case to prosecute. It was a felony assault case. A nice little old lady had punched her sister in the face in the probate courtroom and broke her nose fighting over their mother's china cabinet. And you know, you got to think about what that means. If they're in probate court, that means mom probably didn't have an estate plan. And she probably surely never thought her daughters would come to blows over her estate plan, or she would have done something about it. And we also, to just avoid family conflict, we'd like to avoid probate court altogether, not just because of the fisticuffs, but probate court is expensive. You typically hire lawyers and experts, and you pay court costs and publication costs, sometimes appraisers, all kinds of things to get through probate court. It's also time-consuming. The minimum time to get through a full probate, allegedly is 6 months. It usually takes at least 1 year. There's a lot of steps that have to be gone through to get through probate. Serving as an elder for my church, whenever something legal comes up, they always give it to me to handle. So it's 2017, and we got notified that the church had been named as a beneficiary of an estate. And so they gave it to me, and I went to the lawyer's office that was handling that case, and I'm looking through the receipts and the file to make sure everything's on the up and up and collecting the check on behalf of the church. And in going through the file, I found the death certificate for the decedent, that's the person that died, and it was dated 2002. This case had been in probate for 15 years in Greene County with a will. So probate can be time-consuming. Additionally, probate court is public. A lot of people don't know that. All of your courts are public. Did you know that? If you're ever bored, you can, except for like juvenile cases, if you ever get really bored, you can go to local courthouse, you can find a courtroom that's going on, you can go in, sit down, watch what's going on, and then you'll get really bored with what's going on in court that day. In addition to the courtrooms being public, the files are public also. That means you can go to the clerk's office and you can say, I'd like to see the file on this case. And you can read all of the documents that are in that file, including a probate case. So if someone is in probate, has a probate case open and you know about it, you can go to the clerk's office and you can ask to see the file. And you can see a copy of their will if they had one. You can see a copy of the inventory that their personal representative, which is what we call executors now, filed that lists all of the property that they owned and all of the accounts and how much money they had when they died. Of course, the will tell you what they wanted to have happen with that. You can look and see when they filed and published that there was a probate case open so that all the creditors could file claims in the probate estate to see if they could get paid. So you can see all of the debts the person had when they died. And that's all public in probate court. Now, something nobody knows is that Missouri has the world's most advanced electronic court system. I'm not kidding. It's called Show Me Courts. I was on the implementation committee for the municipal court side of that, serving as a municipal judge. It's all electronic. Everything we do is on the internet. It's on a server in Jefferson City. So we don't file papers anymore. We file PDFs, electronic copies of all that stuff. So everything is electronic. And there's a public facing side of Show Me Courts called CaseNet. And everybody found out about CaseNet in 2020 when they were home and bored and found out that they could get on CaseNet and look up their friends and family and coworkers' names in CaseNet and see if they'd ever been sued or arrested or kicked out of an apartment or divorced or anything like that. You can look it all up on CaseNet. And you can download the files now too. You can download the documents. So if there's a probate case, you can get on CaseNet. You don't even have to go to the courthouse. And you can download the will and the inventory and all the creditor claims, and you can take it right on CaseNet. And that's all public when we're in probate court. So we like to avoid that. And then when we have a plan, we're just going to have an assured outcome. We're going to have some confidence that what we want to happen is exactly what's going to happen. This is my family. We talked about who we're planning for. The only reason I put it in here is because I want to show them off. Okay? I have 3 sons and a wife. That's not my daughter. She's sometimes mistaken for my daughter. Our oldest son, Peter, he's the big one here on the end. He got a 33 on his ACT. And so he went to Truman University, and we're moving him in up there. And my wife's putting sheets on the bed when the RA comes and tries to take her to orientation because they think she's the incoming student. Peter graduated with a pre-med degree, so he drove for DoorDash for 2 years after that. Not medical school, so we had to talk about that. And but now he's down here. He's working for a friend of mine in the insurance business, so he's doing really well. He's got a house here in Rogersville. Our next son, our second son, is Luke. He's in the back with the long hair. He got a 34 on his ACT, so he was very pleased to call his brother and tell him that he beat him by a point. He went to University of Missouri-Rolla and entered their chemical engineering program, which promptly chewed him up, spit him out, and sent him back home with PTSD and social anxiety. So he was living in my house after about a few years of that, and working at McDonald's and doing some things and doing fine. But with that kind of horsepower, we encouraged him. Says, you need to do a little more than that. And we said, just go take a class, anywhere, anything, get your feet back underneath you. So he goes to OTC, and he enrolls in Culinary 101. I thought, great, that's great, good class. And he's excited about it. I think this is going well, and we're about to start class, and I can see he's getting really anxious and really nervous and just the anxieties. And so I was talking to him. I said, what's the problem? Why are we worried about this? This is just a culinary class. You can handle it. And he said, there's a lab. I'm worried about that. He said, the lab was what was causing him the anxiety. And I said, it's not like the chemistry lab that you had at Rolla. It's not like that. It's a kitchen. You're going to cook. He says, I'm not worried about the cooking. I'm worried about having to have a lab partner I don't know. He doesn't like to work with people he doesn't know because of his bad experience. So I enrolled in OTC and I took Culinary 101 so I could be Luke's lab partner. And I got an A, so I'm a pretty good cook. He got a B, so he dropped out of the culinary program, and he enrolled in their bookkeeping classes. So he's my accountant now, and he lives with his brother Peter, right here in Rogersville. Our youngest son is Jack. He turns 21 in a week. He was FFA vice president, Honor Society president here at Rogersville. He was on the Rogersville's national championship trap shooting team. So he's a pretty good shot. But because of that, we had to go to Sparta, Illinois every year for the National World Trap Shooting Championships, and in August, and it's hot. And there's like 5 miles of trap houses where they're just shooting all day long for weeks for all of this. Now, we're only up there for about 3 or 4 days for his section of it, but it was a really hot afternoon, and it was between shoots, and behind all these trap houses are these, it's like strip malls. But all the stores are gun stores. So it's like a Remington store and a Winchester store and all that stuff in there. Well, we're in the Perazzi shotgun store. Does anybody know anything about Perazzi shotguns? Tom, do you know? What would you say is a distinguishing feature of Perazzi shotguns?
Fancy and expensive.
Bingo. Fancy and expensive. And so Jack has got his eye on this Perazzi shotgun. He's begging me to buy him this Perazzi shotgun. He's getting mouthy, and I can give it back to him. And I just said, fine, you shoot 200, I'll buy you a Perazzi shotgun. That's a perfect score and trap. He went out and shot 198 that day and almost gave me a heart attack. I thought I was going to have to buy a $26,000 shotgun. But he didn't, and I didn't either. So he's at College of the Ozarks now. He's a sophomore. He's doing really good. He's studying agribusiness. When he was a freshman, he bought him 3 bredback heifers and started his herd. So he's doing that. He's got him a little fiance. They're planning on getting married in June. And I was trying to get him to go to law school because I need a backup, right? And he's thinking about it, you know. He hangs around with me and he thinks it's a good idea, and then he remembers he has to go to school for an additional 3 years to be a lawyer, and then he decides he doesn't want to do all that. And so I wasn't sure what he was going to do until his fiance told him he was going to go to law school, and so now he's going to go to law school, and we've got this figured out now at this point. But that's my family, and I'm kind of proud of them. And really the point is, what I really want to tell you is those boys like each other. Worst days they tolerate each other. And the worst thing I could do is leave a mess that's going to change that and make them mad at each other for the rest of their lives. So I have an estate plan because I don't want them to get in a fight. I've told them, if you don't like it, you can yell at my headstone. That's fine, you know, but you can't be mad at each other. When we think about writing an estate plan, normally we think about that period of time after we passed on, right? And traditionally, we're always going to think about a will. Will's what usually people think about when they think about estate planning, because wills are thousands of years old. We've been writing them for thousands of years. They're very old documents. Trusts are also ancient documents. We've had trusts for a long time too. But we've only started using trusts for estate planning a little bit more recently. And then there are some other documents that are important as well. But if we're going to write a good estate plan, we have to consider also this period of time when we're still alive, we're still here, we're just either mentally or physically incapable of making decisions and caring for ourselves. That's called, from a legal perspective, it's called being incompetent. So if you're physically or mentally unable to care for yourself, you're legally incompetent. It sounds harsh, but anybody under 18 is also legally incompetent, so you can balance that there that way. When we're trying to deal with this situation, we have to use some different documents. A power of attorney is the correct document to use in this situation. It's important that I clear up some misconceptions. First of all, just for discussion, a power of attorney is not a person, it's a document. And so you and I both, we will always say, I'm a power of attorney, or we'll ask someone, are you the power of attorney? Technically, that's the wrong thing to say. No one is a power of attorney. They have power of attorney. Their title is attorney in fact. So if you have the authority to act on behalf of a principal, your title is attorney in fact, and you have that authority under a power of attorney document. A traditional power of attorney, the attorney in fact has the legal authority to do anything the principal is competent to do. Now, if you think about that, that causes us a problem in this situation. Because if our principal is incompetent, our attorney in fact is also incompetent. So a traditional power of attorney can't solve that problem. That's why we have to use what you've probably heard, a durable power of attorney. A durable power of attorney contains special language authorized by statute so that the authority of the attorney in fact endures past the principal's incompetency. Okay? It's a durable power of attorney. In fact, sometimes we write special documents to where the attorney in fact has no authority to act on behalf of the principal until the principal becomes incompetent, at which point that authority springs to life, which is why we call it a springing durable power of attorney, springing durable power of attorney. We think it's appropriate to write 2 for all of our clients. We write a general durable power of attorney where you give someone the authority to handle your business affairs, cash your checks, write your checks, deal with contracts, insurance companies, all that businessy type of stuff. Sometimes they can do some things with your estate plan if necessary. And then we write in a separate document a healthcare durable power of attorney. That's where you give somebody the authority to make healthcare medical decisions, talk to your doctors. The reason we like to put them in separate documents, even though sometimes people put them all in one, is primarily you may want to choose different people to make those decisions. For example, in mine, my general durable power of attorney names my wife as my attorney in fact. She gets to make those decisions. In fact, mine's not springing, it's immediate. She could be robbing me blind right now and there's nothing I could do. I wouldn't know anything about it, right? But I hold her power of attorney also, so I can do the opposite. She really likes that. She never has to go to the DMV again because I have to go and I can sign for her because I hold her power of attorney in that situation. But We've also specified contingent folks. So if my wife is unable to handle that, then our oldest son, Peter, becomes the attorney in fact. If he is unable or unwilling to do it, then Luke takes over. If Luke's unable or unwilling to do it, then Jack takes over. And so we have some contingencies because we never know what's going to happen, if the people we choose are going to be able to serve when we want them to. My healthcare durable power of attorney is a little different. Again, though, my wife is my attorney in fact. She gets to make the medical decisions for me. If she can't do it, I've named all 3 of my boys to have concurrent authority. So whichever ones of them are around at that point, they can all participate or make the decisions, no matter how many of them are there. If one's there, they can make the decision. If 2 of them are there, they can participate. That's just what I wanted to do. You can do the same contingent order like our other one if you want to. And then the newest document, I talked about wills and trusts being hundreds of years old. These living wills are only about 40 years old. They're brand new as far as we're concerned in the legal field. I think they're better called advanced healthcare directives. We started writing these because of 2 nationally known cases. There was Terry Schiavo in Florida, and Nancy Cruzan was right here in Missouri, up in St. Louis. If you didn't know, in both cases, the ladies were in persistent vegetative states, persistently unconscious. Their body was being fed and kept alive by the machines in the hospital, but there was no reasonable likelihood. The doctor said there's nothing we can do that's ever going to allow them to recover. They're never going to get any better. They're never going to wake up. They're never going to get better. In Terry's case in Florida, part of her family wanted to remove the machines and allow her to pass away naturally. Other members of her family disagreed, and so a court case ensued to decide what to do with Terry. In Missouri, in Nancy's case, it was a little bit different. All of Nancy's family agreed. They wanted to withdraw the treatment to allow her to pass away naturally. The hospital refused, so they had to go to court to force the hospital to remove the treatment. But in neither situation did we know what Terry or Nancy would have wanted if they were able to make the decision, which is why we started drafting. These are the documents where you get to tell people in advance, I would like these types of treatments are okay. These types of treatments I would want to have withdrawn, or I want them all withdrawn, or I want them all given to me, whatever you want. But that's where you get to tell the people what you want. And it's good for us to have the peace of mind that we've told people what we want. But I just want to tell you, having been through the experience and other people have been through the experience, it's extremely important that you do that for the people that are going to have to make the decisions on your behalf. It's almost cruel to ask them to do that in a vacuum, not knowing what you would want. So we encourage everyone to fill those out so that their loved ones will know what to do if they're ever faced with having to make that decision on your behalf. So when do we want to plan? Dr. Bob Hancock is my wife Shelby's second double cousin. So if you'll remember, her parents are both only children. So that means she has no aunts or uncles, which means she has no first cousins. So she only had second cousins. He's a double second cousin. If you don't understand what a double second cousin is, I can explain it later. I promise it's not as hillbilly as it sounds. So Bobby's a veterinarian in Mandeville, Louisiana. His clinic's called Southpaws, and he was known for doing hip reconstruction on dogs. And Shelby and Bobby were pretty close. And it was a few years ago that we found on Facebook his mom had posted that he was in the hospital. And Shelby called Judy and asked what that was about. She said, and Judy told her, said, well, Bobby's been having some trouble, with his kidneys, and so they decided they needed to do exploratory surgery. And when they did that, they discovered a tumor. And the tumor was on his kidney and his liver and his lungs and his intestines. And Judy says it's pretty serious. They're trying to get him stabilized, and they're going to try to do surgery in the morning. But we found out shortly after that in the morning that Bobby had passed away in the night. He did not survive that procedure. Bobby was 43 years old when he died. He was married and he had 2 young children, 2 young girls. And so Shelby and I went to his memorial service in Louisiana. We drove to Mandeville to see the girls and see Bob and see Judy. Bob was Bobby's dad. And when I was down there, his dad, I don't want to say cornered me and asked me about trusts. And it turned out Bobby had a trust. And that was good. He'd taken care of his family by having some estate planning done. But I got to tell you, I was shocked. I really couldn't believe that somebody young as 43 had done any estate planning, because I surely hadn't done it. Most people don't at that age. Just don't really think about it being necessary. So that was important. That was good. But after that, I kind of got to thinking, it's bad enough that we lose one parent, but sometimes we lose both of them. Mom and dad go out on date night, don't make it home. And now we've got little kids at home with a 13-year-old babysitter. And we got to figure out what we're going to do. Because what we realized is that children in that situation have to go to Child Protective Services. Usually a police officer shows up at the home and has to take the children to foster care, essentially. And sometimes walks them right past their grandparents, because grandparents are not legal guardians. Aunts and uncles are not legal guardians, only parents are. And when the parents aren't there, the kids have to go to Child Protective Services. And we didn't like that answer. Fortunately, Missouri doesn't really like that answer either, and it allows us to do some things, and we call that our minor protection plans. So what we can do, if we get the opportunity to talk to families that have young children, is we can draft some special documents in compliance with Missouri law and have them signed and notarized and all that good stuff. And that allows parents to appoint emergency guardians. Those emergency guardians get to have custody of the children immediately, so they don't have to go to Child Protective Services and they don't have to spend any time in foster care. And they get custody of the children while the probate court is determining who the long-term guardians should be. And we can appoint in our documents, we can say, this is who we want the long-term guardians to be, and the probate judge is generally going to respect that unless there's a good reason not to. In fact, these can be the same people, but a lot of times they need to be different people, because for emergency guardians, we need somebody that can come to the house within like half an hour, because we don't want those kids to go anywhere that with somebody they don't know, even if it's a police officer, especially being at the night that maybe they lost their parents. So we need somebody that can respond quickly as emergency guardians, and they get custody of the kids until the long-term guardians, because maybe grandpa and grandma, aunts and uncles, older brothers and sisters, they might live 2-3 hours away or more. So they can't respond quickly. So we appoint emergency guardians that are local. We appoint the long-term guardians for who we want to raise the kids long-term. And we think it's really important. The only problem is we can't get anybody with young children to come and see us to fill out these documents, right? It's a problem. People don't want to do it. They don't think it's going to happen to them, and they're probably right. It probably won't happen to them. But what I do know is it's going to happen to somebody. I just don't know who it is. So if we're going to solve this problem, we have to do these plans for as many people as we possibly can. So to do that, I did what I do. I built a website. So I have a website that lets families with minor children get their minor protection plans. Write it down if you would for me, because I'm going to ask you to tell people about it. It doesn't start with www. That's not part of it. It starts with MPP, Minor Protection Plan. And it's .willworsham.com, my name. So the whole website is mpp.willworsham.com. There's 2 L's in Will. And anybody that goes there that has minor children that lives in Missouri, they have to be Missouri residents, they can get their minor protection documents drafted for $50. That's all we charge. A lot of times we give our clients, because they'll have kids, we'll be representing the grandparents and like, oh, I want my kids to do this, I want my grandkids, right? We'll give them a discount code so they can get it for half price. That code's half down. Sometimes we give people another discount code. That's full down. That makes it free. So now you guys know all the secrets. You can tell somebody what the website is, and you can give them a code that will allow them to get these documents drafted for no charge at all. mpp.willworsham.com, discount code full down, and it's no charge. And all I ask that you do is tell as many people about it as you can. Okay?
Quick question.
Yes, sir.
In that area, say they're going out of town, you need to have them for emergency contact for medical.
Mm-hmm.
Is that in the same area of that or not?
It's real similar, but what we're probably going to do, because you're talking about if temporarily we're going out of town, what do we do in that? A lot of times we'll draft a power of attorney document, a limited power of attorney, to appoint somebody else so that they have to go to take the kids to the doctor, take the kids to something like that. But this could be a stand-in if they needed that.
Thank you.
Yep, thank you for the question. Okay, so we figured out that we need to do estate planning. We figured out some holes in the program, and now we got to figure out how we're going to solve them. So we created a strategic plan to make it as simple as possible. So the first thing we had to do was overcome the initial reluctance to estate planning we decided to do it with education. That's why you're here tonight. That's why we do these presentations, to give people enough information that they can overcome the reluctance and decide, yes, we want to do this, and we know we can be successful when we do it. The next issue was efficiency. So here's what we realized. Once people decided to get their estate plan together, they'd call a law firm, and the law firm would say something like this. Great, what's your name? What's your address? Maybe what's your email address? We're going to send you our intake questionnaire. And you get that questionnaire, and we want you to fill it out. And there's a list of documents that you need to get together, and you get that all together for us and send it in. We'll have a paralegal review it. We'll set up your case file, and then we'll schedule a time for you to come in and meet with the attorney. And what most people would do is they would get this intake questionnaire and the list of documents, and they would start with the best of intentions to fill it out because it's about that thick. And then you decide to finish it tomorrow. And when's tomorrow? Tomorrow is never. Tomorrow's never, right? That's where estate planning goes to die, right there. Too many people get that far in the process and never get any farther. And so our answer was, we're not going to do that part. So we have a different process. Our process involves meeting, after this meeting immediately with one of our paralegals to start talking about what documents do we really need, if any, what information do we need. And by walking together through that process, we realized it can be a lot more efficient that way and we can get the job done and not meet that roadblock of this intimidating questionnaire. So that's how we solved that problem. The next issue was understanding. We found out that many people maybe have an estate plan and don't understand it. The reason I know this is I've done hundreds of these presentations at this point. I honestly can't remember how many I've done. And inevitably, routinely, somebody in the presentation already has a trust. And when I find out somebody in one of my presentations already has a trust-based estate plan, I always ask them, why are you here? And the answer is always the same. I don't understand it. And the last thing I want is one of my clients sitting in some other lawyer's seminar because they don't understand what I did for them. So we had to make sure our clients understood what was doing. We realized that one meeting at a law firm, signing your documents and walking out with them did not create the understanding we were looking for. So we built in a multi-step process. If you look in the back of your workbook, you can see the roadmap that we provide through the entire process of estate planning, and you'll see there are multiple meetings with paralegals and lawyers through the process. In fact, there's a final meeting. It's step 4. It's called a delivery process. That's where you sit down with a paralegal, go through all the documents, ask all the questions that you need to ask, and get instructions on what to do to make your plan successful. You see, a lot of times people walk out of the law firm with their fancy-bound estate plan and put it on the shelf and think everything's good, but it's not. Because there's a whole nother process to make a trust-based estate plan work called funding. You see, if your trust owns nothing, it can't pass anything. It's not effective. And so you have to retitle assets and name beneficiaries to the trust to make sure that the trust actually has the authority to do what you want it to do. And I cannot tell you how many people possess a trust out there that has never been funded. We see them all the time. And so we've got it on the road to make sure that you fund your trust because we want to make sure you're successful. And that's how we build an understanding. And I want to be clear, when I say understand your trust, I want you to understand your trust the same way I understand my truck. Okay? When I say understand my truck, I know how to drive it, I know how to put gas in it, and I know how to take it to the guy that knows how to change the oil. But that's all I know. I don't know how to build it, I don't know how to repair it, I don't know how to take it apart. I leave that to the professionals, right? And so when I say I want you to understand your trust, I want you to understand how to use it. I want you to understand how to drive it. I want you to understand when you need to take it in for maintenance. And I need you to know to take it to a professional when you need to take it in for maintenance because that's how we make sure it's successful. The next point we decided was that sometimes people get their trust and they understand their trust and things are going well, but time happens. Time goes by. And two things happen when time goes by. Memories fade and things change, right? So maybe we understood that trust when we walked out of here, but 2, 3, 4, 5 years down the road, maybe we've forgotten something about it. Maybe somebody got married. Maybe somebody got divorced. Maybe somebody was born. Maybe somebody died. Maybe a law changed. And when any of those things happen, we know in the back of our head, or maybe the front of our head, we really need to call our lawyer and ask what we need to do. But everybody's really reluctant, sometimes to the point that they will not call a lawyer and ask those questions. Why not? Free. It's not free. Is it? Yeah. It's expensive. It's expensive to call lawyers. The only thing we can do is sell our time. I have no practical skills whatsoever. This is all I can do. So the only thing we can do is sell our time, and so that means people don't want to call lawyers and ask questions, and I understand that. But I had to figure out a way to get past that. I had to figure out a way so that my clients would at least have the opportunity to ask the legal questions they needed to ask. And I got to thinking about it. And you know, when we work with our clients, we have an electronic case management system. It's called MyCase. So all of our clients right up front get an invitation to log on to our MyCase system, and it's got some really neat features to it. One, it has an online file storage. So documents, anything can be stored on there. So all the documents we create are stored online in PDF files so they're readily accessible at bank level security. It also has a messaging system. Kind of works like social media a little bit. You can comment on the items that are in there. You can comment on the appointments. And you can send messages back and forth. And we found out that works really good while we're working with our clients in developing their estate plan. But then I realized the one place that nobody is ever reluctant to ask me legal questions is on Facebook. People will message me questions on Facebook all the time, and I thought, I just need to figure out how to make that work for my clients. And so what we did was we just said, what if we let people keep this My Case system where they can ask questions online anytime they want and get answers to their legal questions, whether they're related to their trust or not. And so we did that, but we couldn't make it free because we still have to pay the bills and the rent and all that stuff. So what we do is we have that as an optional low-cost subscription for all of our clients. Most of our clients decide that's something they want to try. And in about 7 years of most of our clients opting into it, we've only had about 10 cancel it. So what we found is it's a pretty good value and people like it. So that's how we solved that problem, to make sure that people always had online access to their documents. So if we lose our originals, we've got copies secured on the portal as part of that subscription program. And also, we can make some minor changes, and we do that for no charge for our clients that have subscriptions too. So if we need to change, make an adjustment to the beneficiaries, if we need to change who the trustees are or something like that, we do all that at no charge. We also do new updated power of attorneys every 2 years for our clients that want it, and that's all built in to the subscription process. And it's optional. Nobody has to do it. But those are the 4 problems that we saw as the major obstacles to good estate planning and the way we tried to solve them. When we talk about estate planning, there's a couple different ways people try to get it done. Sometimes people just decide not to have any plan. And we know that if we don't have a plan, there's a likelihood of probate court and the possibility of family conflict. So it's better to have a plan than not have a plan. Most people, when they think about estate planning, think about having a will. And I want to talk about a will because I want to be clear. Wills do not avoid probate. Wills are instructions for a probate judge. But a lot of people don't know that. I've had a lot of people tell me, I don't have to worry about probate, I have a will. And I tried to figure out, why do so many people think wills avoid probate when they clearly don't? I mean, they right up front ask the judge to appoint an executor, right? And I decided it's Hollywood's fault. Have you ever seen the movie where somebody's rich uncle dies? What's the next thing that happens in the movies when somebody's rich uncle dies? They go to the reading of the will. Nonsense. I don't think that happens in real life. I've never seen that happen. Because a will has to go to probate court. Even if you got in the lawyer's office and you read the will and you're like, oh, that's great, you're still going to probate because that's what makes a will work, a probate court. So wills are not going to avoid probate. So wills really aren't the plan we're looking for because remember, we want to avoid probate. So some people get smart and they decide, well, I'm just going to retitle my assets. This is where maybe I put my daughter's name on my checking account, I put the kids' names on the farm, the boys' names on the farm, on the cars and all on the title and all of that stuff. And a lot of people think that's really handy, especially the checking account deal, because then the daughter can sign checks for the mom. You know, maybe the Parkinson's or the arthritis or something, she doesn't like to sign checks anymore, so daughter can sign. It's really handy. Works out great. It avoids probate because we just gave all our stuff away, right? So it's an issue. Ben, I'm going to ask you, do you have a check account? Mm-hmm. Would you make me a joint, put me on there as a joint? Probably not. Probably not. Yeah, probably not. Because if I was joint on your checking account, what percentage of whatever you have in there, I always say percentage now because I asked somebody one time and they told me how much was in their checking account, and I really don't want to know that. But what percentage would I be able to withdraw if you just put me on as a joint on there? 100%. I can take it all, right? If we're joint owners, we're full owners of that. So imagine for me, if you will, we've got a young man in a circumstance whose parents have decided to avoid probate by putting his name on all of their stuff, all of their accounts, their home, cars, all of that stuff. And he gets invited by a friend of his to come out to Las Vegas. His friend lives in a penthouse apartment in Las Vegas, okay? So he goes out to visit him, and when he gets there, he's tired from the flight, so he decides to take a bath. But his friend doesn't want to wait on him, so his friend goes to the casino. And I guess his friend was doing well because he called him and said, the slots are hot, you need to get down here. Well, now he's excited. He jumps up, he gets dressed, he runs down the casino floor. They played the slot machines all night. Whether they won or lost, I don't know. It's kind of irrelevant because when they got back up to the penthouse, they realized he forgot to turn off the bathtub. And he flooded the apartment. Now, when you flood a penthouse apartment in an apartment building, what else do you flood? Everything below it. Turns out it did $750,000 worth of water damage to this apartment building in Las Vegas. Good thing for the owner, he had insurance, and the insurance company pays, and they have the apartment building repaired, and everybody's happy except for the insurance company. They want to know who's responsible. They find out. They sue him. They get a judgment against the young man for $750,000. Of course, they can't collect it from him because he's a young man, he doesn't have any assets, and he doesn't own anything. So where are they going to collect their judgment? What does he own? Mom and Dad's bank account. Part of Mom and Dad's cars, the farm. His name's on all of that. He's an owner. They can levy those assets. And so when we put other people's names on our assets, we may trust that they're not going to withdraw it personally, but we have now subjected that asset to their creditors, right? It's not a good idea, but fortunately, we have a better option. Missouri has what we call the non-probate statute, non-probate plan. It's in chapter 461. What it lets us do is we can put a payable on death designation on our checking, all of our bank accounts, checks, savings accounts, CDs, money markets. Payable on death, POD. A lot of people hear POD, people say that. If we have anything at the Department of Revenue, anything that has a title, car, truck, trailer, anything like that, you can put a TOD on that, transfer on death designation. It doesn't make them a current owner. It doesn't transfer it until after the primary owners pass away. For real estate, we can draft and file what's called a beneficiary deed. We call them Benny deeds sometimes, just to say it quickly. Beneficiary deed. It will convey the property after the original owners pass away. So we don't have the liability attachment to that. And it's a good plan to use. We still have the problem of what we call personal property. That's your clothes, your tools, your jewelry, your furniture, your guns, all those things at home that don't have titles or other certificates of ownership. We may have to go to probate to deal with those issues, but if it's under $40,000, we can probably handle it on what's called a small estate affidavit. So that's a good plan, and we like that, but we have to consider. Think about what can happen if, for example, say Fern and Pete were really wise and they use these wonderful tools that Missouri gives us and leaves everything to Danny. Did we solve the problem? I mean, he inherits it, that's great. At least he didn't have to go to probate, but when he dies without a plan, it still goes to that second wife, and we still accidentally disinherited our grandchildren. So that tool doesn't let us solve that problem at all. You can even think, well, what if Danny and his second wife use those tools and they named all 4 of their children, his and hers, as the beneficiaries under those documents? Does that solve the problem? Well, I wouldn't ask if it did, would I? Because when he passes away, who's still the sole owner of all that property? The second wife. Is she stuck with the decisions they made before? And she doesn't have to keep that house. She doesn't have to keep that car. She doesn't have to keep those accounts. She can change all of that, and probably would. What happened if she gets remarried and then she dies? Now we've got yet another person that's transferring the property to that. Now we really don't even know who that is. So these tools are good, but they don't let us plan for that type of contingency. What if our beneficiary that we've named that's going to inherit all this property has a large creditor? Or is a spendthrift? If he flooded an apartment, he's got a judgment against him for $750,000. Now who's our beneficiary? That insurance company is. They're going to get it. What if they're bad with money? If they get a large inheritance, they're just going to go out and buy a bunch of Perazzi shotguns or something, right? They just waste it all. That's not a good plan either. There's another situation that could come up that people used to argue with me and would tell me it probably wouldn't happen, never happen, and they're probably right. But unfortunately, I got a really good example. If you'll remember, a few years ago, we used to have this tourist attraction down at Branson called Ride the Ducks. If you didn't know, this was a tourist attraction. You could buy a ticket, you could get on this vehicle, and it would drive around Branson and then drive right off the launch into the lake and float because it was an amphibious vehicle. And so you could buy a ticket and you could go out on this thing. Well, they went out one night, and it was stormy, and it sank. They shouldn't have gone out. And 17 people drowned off of that boat that night. And what we found out later was 7 of them were all from the same family from Indianapolis and Branson for a family reunion. And it unfortunately gave me the perfect example I needed to say, what if all of the people we name all die out or near the same time we do? Now we have another failed estate plan. So these are good tools. We like them. We use them all the time. But the problem comes when people try to use them without any other planning around them to deal with the contingencies. And so we like to use them with our trusts. So a trust-based estate plan keeps us out of probate. We leave clear instructions to avoid conflict. We have no exposure to the liabilities of our beneficiaries. And it allows us to plan for both known and unknown contingencies. We like trusts. So let's talk for a little bit before we get out of here tonight, just what a trust is anyway. So a trust is just an agreement. It's a written agreement, written instructions. We're going to write it down. And it has three roles. We have a grantor. A grantor is the person that creates the trust, sets the rules of trust, and picks who the other people are that are going to be involved in the trust. They're going to pick a trustee. A trustee is the legal owner of everything in the trust. As trustee, they are the owner of what's in the trust, and they are legally obligated by the terms of the trust document to use those assets only for the benefit of the beneficiaries, one or multiple beneficiaries. So we have a grantor, a trustee, and a beneficiary, and when they're all alive, when we're doing estate planning at the beginning, when we form our estate plan, it's called a revocable living trust. A trust is simply a legal document establishing the various roles and their rights and responsibilities. So let's talk a little bit about how this is going to work. Clayton, will you be my trustee?
Yes, sir.
Thank you. We're going to use that bucket to illustrate a trust. And remember, we have to fund our trust. Luckily, I have some cash. We'll fund that trust. So, Stephen, is it? Stephen, will you be the beneficiary? You're smiling. You like that? Stephen's going to be the beneficiary. Okay, who's the grantor? I am. I made it, right? I put the stuff in it. I picked the people, right? Okay, I'm the grantor. Now, this is a revocable trust. That means as grantor, after I establish a trust, I have one superpower. Because it's revocable, that means I can change it anytime I want. Okay? So I can change this trust anytime I want. Who owns what's in the trust?
You. The trust.
Missy, good job. The trustee owns everything that's in the trust. It's really important to understand that the trustee is the legal owner of what's in the trust. Okay? Trustee owns what's in the trust. Can Clayton, as trustee, use what's in the trust to buy my lunch? No. Can he buy his lunch? No. Can he buy Stephen's lunch?
No.
I left out a part. You know, he's obligated to use what's in the trust in his best discretion for the beneficiary's health, education, maintenance, and support. Health, education, maintenance, support. So let me ask you now, can he buy Stephen's lunch?
Yes.
Sure. What happens if we don't eat? It's not very healthy, is it? Right. Can you pay for Stephen's college tuition? Education, health, education, maintenance, and support. Can you pay for his medical bills?
Yes.
Can you pay for his Caribbean cruise?
Nope. It depends if it's order bill.
Oh, so who gets to decide? Who gets to decide?
I would say the court. Trust.
The trustee, right? I trust him, right? So he gets to decide if he's going to pay for that Caribbean cruise or not. Okay? Because we might need that for mental health purposes. You know, it might be a good thing. Can we buy him a car?
It all depends.
Maintenance, support, we got to get to work, got to get to class. He needs a car. It's the trustee's decision within the terms of the trust how to use those assets for the beneficiary's health, education, maintenance, and support. Now, if Stephen upsets me, what can I do about it? I'm the grantor. What's my superpower? I can change it, which means I can change beneficiaries. Well, if I remove Stephen as beneficiary, I need to pick a new beneficiary. I'll pick me. Now who's the grantor? Still me. Now whose lunch can Clayton buy? Mine, right? Now whose Caribbean cruise can he pay for? Mine. Does he have to? No, he doesn't have to. It's his decision. But
You as the grantor, can you dictate what those decisions are? You know, some
The terms of the trust are going to dictate those types of decisions. Yeah. If he tells me no, what am I going to do? I'm the grantor. I can fire the trustee. So now I need a new trustee. I'll pick me. Now who's the grantor?
You.
Who's the trustee?
You.
Who's the beneficiary? What can I do with what's in my trust? Anything I want, I'm in total control. Do I still have a trust? Yeah, because it's a written document. And my written document says, I'm the grantor, I'm the trustee, I'm the beneficiary. So that I can do whatever I want with what's in my trust. Now, why would I do such a thing? I want to avoid probate, remember? So I've created a trust that says, I'm the grantor, I'm the trustee, I'm the beneficiary, I can use everything in the trust for my own benefit. Oops. But if I die or become disabled, I get to name successor or contingent trustees, right? So that means, for example, if I kick the bucket, I name a contingent trustee, Clayton, that picks it up. Now, if I die, who's the trustee? Clayton is. Do I need to go to probate to find out who owns the property? No, we don't need probate because Clayton owns it now, because the trust says it does. Who's the grantor now?
I guess me.
It's me. It's me. I'm still the grantor, right? Who can change the trust now? Nobody. Nobody can. That's perfect, right? Now, I don't need, now if I'm just disabled, who's the beneficiary? Still me, right? He's the I'm disabled, I'm in the long-term care, I've got Alzheimer's. He's the trustee, I'm the beneficiary, so who's he using what's in the trust for? You. Yeah, me. Right. He's probably also my attorney in fact, by the way, because he's performing a similar role. Make sense? Okay. But if I pass away, I can't be the beneficiary anymore. That would be pointless. So I'm going to name contingent beneficiaries. So once the grantors die in the trust document, maybe Clayton is going to be the contingent successor trustee and a contingent beneficiary. And Stephen's going to be a beneficiary, a contingent beneficiary too. And the terms of the trust will tell Stephen what he's supposed to do when the grantor or grantors, if it's a joint trust, when they've both passed away, what he's supposed to do. And the easiest way to do that is say, Clayton, you take your half, give Stephen his half, and we're done. We've distributed all the assets out of the trust. There's nothing left in the trust, which means by operation of law, the trust dissolves, and we're done. Now, you're going to pay the last expenses and pay the debts and things like that after the grantor passed away, but what's left? And we don't have to go to probate to decide that, because it's all private, right? It's great. It's a great way to avoid probate. We get things done. But we can have fun with our trusts, too, okay? So maybe we're going to say, I want you to divide this in half, and I want you to take your half. That's yours because you're the successor trustee, successor beneficiary. But we're going to hold on to Stephen's. We're not going to give Stephen his. You're going to keep it. And you're going to be the trustee for his ongoing trust, and you're going to use what's in this trust for his health, education, maintenance, and support. Because I don't think he's very good with money. I'm afraid he's going to waste it. So I don't want him to lose it. I want him taken care of, and I want you to take care of him with this inheritance I've left him. Okay? So I can protect Stephen from himself by leaving his inheritance through a trust in an ongoing trust for his benefit. Okay?
Is that a separate trust you got, or is it
It's a continuing trust, essentially. Yeah. And I mean, you can do all kinds of things like that. Maybe I don't have that kind of a problem with Stephen. Maybe I think he's actually fine with money. That's not a problem. But his no good wife, Missy, I'm a little worried about her. I'm afraid she's going to steal it all away. Maybe she's the second wife, right? So I leave it all to Stephen in a trust, and I say if something happens to Stephen, the contingent beneficiaries of that trust that we've left to him are his kids. Now she can't inherit from him. It's going to go to my grandkids that way. You see how I just solved my Danny problem? Yeah, we can use a trust to solve that problem. Okay? I could actually do it differently. I could say we're going to give Stephen his, but I'm going to say, Clayton, you keep yours in a trust and manage it for your own benefit because I don't want Carrie to get it, right? I still left you in control of your own trust, and she could probably talk you out of it and get it put in a joint account, but I'm going to trust you not to do that. I've tried to solve the same problem, but I made it a little softer, right? So you don't have to ask somebody else to do that. And then we have contingents. You know, it just says if Stephen's passed away, then it goes to his kids. We're going to skip Missy here too, right? Even if they're her kids too. We're going to skip her. We're going to give them to his kids. They're the contingent beneficiaries. And if they're under 25, you're going to manage it for them until they're 25.
That was my question.
Yep. Right? Because we don't want to give inheritance to people under 18, and I don't like to give inheritance to people under 25. We can change that number if we need to. You see how we can have all kinds of fun with trust? Lots of stuff. Okay, last topic.
Real quick,
Yes, sir.
how would you protect the assets? Say, for example, a son or daughter gets married, and you might think that might get divorced, and you want to protect the initial asset to the child, but not to the...
Yeah, same way.
Okay.
You leave the inheritance to that child in a trust for their benefit and not their spouse's benefit.
So joint doesn't count?
Doesn't count because we're never going to give it to them. They're never going to have the ability to put it in a joint account, right? That's where the trouble comes in.
Joint ownership.
They don't have joint ownership because they don't own it. Who owns it?
Okay.
The trustee.
Okay.
And the trustee is going to use it for their benefit. We're not ever going to give them cash. We're going to say, oh, you need a car? I'll make the payment.
I see.
Oh, you need health insurance? I'll make the payment. You need college tuition? I'll pay the college. We're not going to write them a check for cash in that type of situation.
Very good, thank you.
My pleasure. Okay, so the last topic is about long-term care. I didn't used to talk about it, but it kept coming up. So the reason long-term care becomes an issue is the cost of it. If we have a Alzheimer's diagnosis or a stroke, which are the two main reasons people wind up in long-term care, if it's an Alzheimer's diagnosis, the national average says that we're going to be in long-term care for 8 years. The average cost of long-term care nationally is $8,000 to $10,000 a month. Around here, we're a little cheaper. It's about $7,000 a month. But who thinks that cost is going to go up or down? Probably going to go up, right? So that looks like $1 million problem that we're going to have there, right? If we have 8 years, 96 months at $10,000 a month, we're at $960,000. We'll round up to $1 million. Okay? So the average cost of long-term care is approximately $1 million. If we're going to spend $1 million or $8,000 to $10,000 a month on long-term care, that can put a healthy spouse in a very difficult situation at home with that outgoing money all the time. And it can actually wipe out an estate. So we can solve that problem by taking advantage of the Medicaid program, but when we consider Medicaid, we have two issues we have to overcome. First of all, we have to qualify for Medicaid. To qualify for Medicaid, we have to be unable to pay for long-term care ourselves. That means we are out of cash. We've spent all of our cash, all of our savings, all of our investments, all of our retirement. We've cashed out our life insurance policies. If we have annuities with cash value, we've cashed them out. We've spent all our money. Now we can qualify for Medicaid, assuming our income is insufficient to pay for care. So if we have a retirement income of $8,000 to $10,000 a month, that's going to go to pay for long-term care, and we're not going to qualify for Medicaid. But the situation we usually find ourselves in is that healthy spouse at home was relying on that income, or at least part of it, right? And now it's gone because it followed the other person into long-term care. Once we qualify for Medicaid, and Medicaid is paying for our long-term care bills, we need to avoid the Medicaid lien, or what they call recapture. So what Medicaid does is if they have paid for our health care through our lives, our long-term care, they've kept track of how much they've paid, and then they come to our state, usually after the last spouse has passed away. They don't typically, well, they don't assert it against a surviving spouse, but they want to be repaid out of the estate. So they're going to assert a lien, and that lien will go on all the property. In fact, it can attach to any property that was within the applicant's name within 5 years prior to the date they asked Medicaid to pay. That's called the look-back period, 5 years. And so the way that can work, for example, is in 2012, there was a court case. And a decedent, a person who'd passed away, had drafted and filed a beneficiary deed leaving their family farm to their children, and then went into long-term care. They exhausted their resources, and Medicaid paid their long-term care bills for a period of time. When they passed away, of course, the beneficiary deed kicked in and passed that farm directly to the children outside of probate. But Medicaid said, wait a minute, that farm was in our patient's name up to the very minute they died, including all the time they were on Medicaid, so they were within the look-back period. And Medicaid, or MoHealthNet, is the administrative agency that administers Medicaid here in Missouri, opened up a probate case, forced open a probate case, and asked the judge to claw back that property away from those beneficiaries into the probate estate. And the judge did that, because he had to, and then Medicaid or MoHealthNet asserted their lien and took the farm. So they took it right away from the beneficiaries using their clawback powers. It's kind of like a special power. So any assets that are in the name 5 years prior to the date we apply for benefits is subject to that Medicaid lien. The way we solve both of these problems is by using an asset protection trust. A Missouri Asset Protection Trust, or MAPT, is a special time of irrevocable trust. So if you remember, our revocable trust, we use this bucket, right? Because it's got a big open top, we can put things in, we can take things out, and as grantor right a superpower, I could change it. An irrevocable trust, because we're using it for asset protection, I can't change it. The grantor cannot change an irrevocable trust once we create it. And if you'll remember, in the revocable trust, while I was happy, healthy, and alive, I was the trustee and I was the beneficiary. But we're trying to protect assets from creditors, including Medicaid, which means if I can get into this trust, a creditor could potentially force me to use what's in it. So that means I can't be the trustee. I can't have the key. And also, it can't be for my benefit. If this is for my benefit, well, it might have to be spent on long-term care. That's health care, right? So I can't be the beneficiary. So while I'm going to be the grantor and I'm going to create this irrevocable trust, I'm not going to be the trustee. I'm not going to be the beneficiary. Maybe my kids are going to be the beneficiary, right? Now, the first asset I want to protect from a Medicaid lien is going to be my house. Usually our homes is where we have a good chunk of our wealth, right? We've built equity, we paid off our house. This is maybe the main asset we're going to be able to pass on to our heirs. So I'm going to take my house and I'm going to put it in this irrevocable trust. Who owns that house now?
The trust.
Yeah, not me, the trustee. So we'll make you the trustee here, right? I don't own that house. My trustee owns it because it's in the trust. But I'm going to reserve the right to live in any residential real estate owned by that trust. So I get to keep living in that house. It also means I have the responsibility to pay the taxes, the mortgage, the insurance, the maintenance, and keep up with it. It's really kind of like I own the darn thing still. But I don't. Legally, it's not my house anymore, which means a creditor can't attach it. No creditor can attach it, including Medicaid, as long as it's been out of my name for 5 years prior to the date I asked Medicaid to pay for my long-term care. So my house is safe. But maybe I have too much cash and I'm never going to qualify for Medicaid because I've got $1 million. But I don't want to give the nursing home my $1 million I've worked for my whole life, right? I want my kids to get it. So I'll just take my $1 million and I'll put it in this irrevocable trust, right along with my house. Can I have that back? No, it's not mine. But what I can do is reserve the right to receive any income generated by the assets owned by the irrevocable trust. So you take that $1 million and you invest it, right? If you could get 10% return on that, it's $100,000 a year, and I get that. That comes to me, right? So I still get the income off of it. Now, we have to do some financial planning and decide what the appropriate amount is that we're able to do that with and those things, and that's beyond my pay grade to make those types of decisions. But we create the trust and we do that. You know, maybe I don't want to live in that house my whole life. You know, it's a lot to take care of. Well, I could ask Clayton, my trustee, I could say, I'll give up my right to live in that real estate. Why don't you sell the house and then take the proceeds and go buy me a condo at the lake, and I'll move into that piece of residential real estate. Now, when he sells my house is maybe worth $500,000. Where does the proceeds of that sale go? Yeah, it's got to stay in this trust. So you take the money from the proceeds, you spend half of it, $250,000, on that condo. Now we've got $250,000 in the trust. Can I have that? No, it stays in the trust. But what can I get?
The interest.
The interest off of it, the income, right? If I go into long-term care, assuming it's been 5 years, can you use anything in here to pay for my long-term care? No, we can't. It's not for long-term care. And when I pass away, nothing can touch it. It's been out of reach for a long enough period of time to satisfy the look-back period. And you have instructions with this trust, just like we did with our revocable trust, on how we want to distribute the assets after the grantors pass away. So now you can take the key and you can open the trust and you can distribute it to the people that I've asked you to distribute it for. Okay? Makes sense? There's some other nuances to these irrevocable trusts too that we are happy to discuss. Okay. So, thank you for coming. I appreciate that. As a thank you for coming, we're going to offer a free discovery session. So, all you have to do is sign up for that. The catch to that is we would ask you to sign up before you leave tonight. Okay? So, Tiffany is here and Tony's here, and they're going to meet you on the way out. Okay? That discovery session, you're going to be able to ask some questions, get some clarity on exactly what you want your plan to look like. After that, you get to schedule an appointment, and you'll meet directly with me, and we'll design your plan. Okay? Thanks for coming.